Begin with reckless driving. Reckless driving, our definition on reckless driving is irrespective of the maximum speeds permitted by law. Any person who drives a vehicle on a highway recklessly or at a speed or in a manner so as to endanger the life, limb, or property of any other person shall be guilty of reckless driving. So that's the standard that the judge is looking for and measuring against. Now, reckless driving, people like to call, oh, I've been charged with reckless driving. And I initially want to ask them, well, what type of reckless driving? And they're just like, reckless driving. So we walk through, is it reckless driving by speed? Is it reckless driving by passing a school bus? And it's amazing how many varieties there are. Everywhere from faulty brakes, failure to maintain control, passing on a railroad grade crossing, driving two abreast in a single lane, passing a stopped school bus, racing. So there's quite a variety that we don't think of as really rising to the level of a criminal misdemeanor. And the reason so many people call about reckless driving is at the scene, the officer just says, well, you were speeding, you were going too fast. They get home and they look at it and they realize, I can't prepay this. This is a criminal misdemeanor. So what I generally do is when someone calls, I just explain the difference. A traffic infraction never goes on your criminal record. It eventually comes off of your DMV record. Whereas the reckless driving cases, permanently on a criminal history, you'd perpetually have to explain, oh, it was just a traffic infraction, but it's permanently going to appear on a criminal history. And your driving transcript, it would be on for 11 years. So as soon as we start talking about the options, then we start recognizing, boy, this isn't just something to take lightly. The most frequent call is the reckless by speed. And it's funny because in Virginia, ours becomes a misdemeanor offense much earlier than other states, and some states never criminalize their speeding. So whatever speed, it's still not going to go on a criminal transcript. So I'd just like to walk you through, if I'm explaining to someone like what I would do to help them on a traffic charge. Sometimes people will call and it'll be so close that I just tell them, you should just go to court on your own and show them your good driving record and tell the judge to amend it, because the judges in that particular court, 9 times out of 10, they're going to amend it for you. On the other hand, as you start getting further away, like someone's got 81 and a 60 with a perfect driving record, most of the peninsula judges are going to say, yeah, we can give them some other charge. But you start edging up closer to 85 or pushing it on up to 90, we're going to have to they're really going to make us do our homework. So what I generally do when I go to court is, the first thing I do is I go and find the officer. I meet with the officer. The peninsula is a great place to work. Our officers and troopers will generally meet with us. They'll share their notes with us. They'll share their certifications with us. What we look for are, can the officer prove the accuracy of his radar or laser equipment at the time of the offense? So they have to bring a certified document dated within 6 months before our stop, or we can ask for a full dismissal of the case. And you'd think day in, day out doing the same thing that they would always have that, but we've seen everywhere from bringing documentation for the wrong piece of equipment, like he brought it for his car, but he was using radar that day. We've seen them with outdated or post-dated records. We've seen officers show up without any records at all. All of those are grounds for us to ask for a dismissal. If they have what they need, I typically will then interview them about their notes. At that point, what we're doing is we're looking for, did he cause a problem? Did he interfere with other vehicles? Did he cause any problems? Because what I like to do is, once the officer testifies, I want the judge, the next thing he hears is all the good things that my client did out of the same officer's mouth. So he didn't do anything other than the speed. That's right. He didn't interfere with any other vehicles. That's right. He responded appropriately to the emergency equipment. That's right. And we just walk through a list so that by the time we're presenting our information, the judge has heard a lot of good things about our client. Some of the things that we like our clients to do are bring us their good driving record. We have so many military that if an officer pulls a Virginia, it's not really going to tell the judge anything. So we have them pull their Ohio or Mississippi or wherever they're from, and then the judge can really see, here's a track record of this is an aberration. This isn't typical of the driving. The other thing is the driver improvement courses. The driver improvement courses will give you 5 positive points on your license. And with that, most traffic offenses, or all traffic offenses, will be either 3, 4, or 6-point violations. So what we try to do is if anyone has any type of blemish on their record, get them into traffic school and come to court telling about what they learned. It's not very helpful to tell a judge, oh, look, I went to traffic school. But if somebody stands there and says, I went to traffic school and I learned such, such, and such, or I was reminded of, is even better. Because a lot of judges are quick-witted and they'll be like, so the first time you ever knew to pay attention to the speed limit was when you went to traffic school? You know, that doesn't go over too well. But if we can have them kind of just say, you know, it reminded me of, and kind of walk through it that way, it helps a good bit.